I am just delighted to be here with three of my friends to talk about the antitrust laws because it's been much in the press. First, let me introduce Phil Weiser, whom I've known for almost 30 years. I met him immediately after his clerkship with Justice Ruth Bader Ginsburg when he was working at the Antitrust Division. Phil is now the Attorney General of Colorado, having previously been a professor and a dean at the University of Colorado Law School. To Phil's left is John Thorne. I met John when he was my client. He was the head of antitrust for Verizon. He's now a partner at the Kellogg-Huber firm in Washington, which does a lot of antitrust litigation. And at the far left is Logan Breed, who was my partner at Hogan Lovells and is my successor as the head of the antitrust practice at the firm. We wanted to get this program together because antitrust has been much in the news. I'll have a slide later that will talk a little bit about the kinds of cases that have been appearing in the news. But we're going to focus today on two cases that have been much reported. First, we're going to talk about the grocery store merger, which would have had a big impact here in the Valley because of the grocery stores that are 100 yards apart in West Vail. Phil challenged that merger, successfully in the sense that the Federal Trade Commission blocked it, but Phil's still awaiting a decision in state court. And then we'll talk about, and then Logan, who was not involved, will talk about the defense that was presented by the grocery stores to try to get the merger cleared. We initially invited the lawyers who had handled the case, but because they are suing one another, no one was willing to come forward and speak. Then Phil will also talk about the Google search case, which was brought by a number of states, including Colorado and the Department of Justice, and resulted in a decision by a federal court in Washington that Google was a monopolist that had abused its position. So Phil will talk about why he brought that case, and then Logan will present what Google's defense was. Excuse me, John will handle that. So to tee up these issues, I want to just pose three questions that these three panelists will address in the course of the discussion. What were the enforcement and defense arguments in the cases? Phil will explain why he chose to bring them. Then what were the potential harms to consumers that caused the cases to be filed? And why do these cases matter? But to set the stage, I want to spend a very little bit of time explaining to you, because you're not antitrust lawyers except with a couple of exceptions in the audience, the background of the antitrust laws. So the purpose of the antitrust laws is to provide competition. The whole theory is that competition in a free market will produce the best products, the best prices, and the most innovation. The first American antitrust law was enacted in 1890, the Sherman Act, named after not General Sherman, but his brother, who was a senator from Ohio. Most of the states, including Colorado, have their own antitrust laws, and cases can be brought either under the federal laws or the state antitrust laws, or both. Notably, Phil's case against the grocery stores was filed under the Colorado state antitrust law. The Google case was filed under the federal antitrust laws. Now, in addition to all the American laws, there are 120 countries that have antitrust laws. And so when we have had mergers that are global, we have to deal with merger authorities all over the world. And it has brought new elements of complication to all of those proceedings. So the first purpose of the Sherman Act is to prevent illegal agreements that restrict competition. Price fixing, bid rigging, market allocation agreements saying, okay, you guys take Colorado, we'll take Nebraska, something along those lines. And then they also prohibit arrangements that produce market power, either as a result of the conduct of a single firm that has a lot of market power, either acquiring that market power or maintaining it in ways that violate the law, or through mergers and acquisitions that might create market power. The enforcement at the federal level is by the Department of Justice and the Federal Trade Commission. The states have their own attorneys general who can investigate transactions or conduct. There's civil enforcement by private plaintiffs, either for damages or injunction, and the foreign antitrust authorities have the ability to cover a lot of conduct as well. So these are some of the headlines that you will have seen recently about some of these cases. And they're not just in the trade press now, they're on the front page of your local newspaper or the Wall Street Journal or the New York Times or the Washington Post. So we want to provide an explanation of how all of this really works and why this is important to you as consumers. So, Phil, why did you bring the case?
What is so interesting and important to visit about tonight is this case, this grocery store mega merger case, is one that everyone here can relate to. I've worked on lots of different antitrust cases. There's so many important antitrust cases, and a lot of the time, they're products that you might call upstream when you think about what gets to a consumer. So, for example, there could be a merger between, let's say, two of the people who make door parts that would ultimately raise prices of doors at Home Depot. But if you ask people, what do you know about these two door part manufacturing firms, you'd get blank stares. When you say to someone, what do you know about City Market and Safeway? You say, well, sometimes I go to Safeway and sometimes I go to City Market because sometimes they have eggs at City Market. Unfortunately, this is a too relevant example right now. And they don't have eggs at Safeway. Or I look at what is on sale each week and I shop at each store. Or they have certain types of different items at one store I like and others at another store. I did a town hall here 18 months or 24 months ago, and I asked that question to the community. And I got the answer, we like having these stores as rivals. And I got a couple other points from that conversation. And I want to acknowledge you all because it's a big deal for the case. You all know this because you live this. In Vail, there's a City Market right near the Safeway. But in Eagle, there's only City Market, right? There's no Safeway. And you know what's interesting about the City Market prices in Eagle? They're higher. We did discovery in this merger. This is what happens in a case. You ask the parties, give me all these documents. We get a document, and there's a list of what they call, I'm not making this up, no comp stores. Stores that don't have competition. One of those stores is in Eagle, and the company reports they can charge more money in Eagle than they can in Vail. So for those of you who actually compare those prices, it's not your imagination. The companies have said that. Now, the companies came into me, and I know we'll get to this, and they offered their defense. And I've heard other people make this argument. They say, oh, don't worry about us merging. There's Costco. You know what is right down the road from the City Market in Eagle? A Costco. But yet they still charge considerably more in Eagle than they do in Vail, because when you think about what I'll call true competitors, Costco is not a true competitor. You got to buy in bulk. They don't have everything you need, and you have to pay like a membership fee. We made a judgment after we did our initial investigation that really there's three basic supermarket chains. There's Albertsons, Safeway. There's Kroger, which is City Market here. And there's Walmart. And there are a lot of communities where they either have only 2 or 3 of those stores, and they don't have much choice. And if these stores merged, it would be what antitrust lawyers would call either a 3-to-2 merger, or in some cases, a 2-to-1 merger. And part of the fear is on resilience. If one has eggs and the other doesn't, but yet you only then have one, you have no eggs. a lack of competition for prices, harder to get local food in the store. And I went around the state, we had 19 of these town halls, and that's what I heard. And so why I brought this case is because I listened hard to the people of Colorado. And this is something, when I was at the Department of Justice, I didn't realize what I was missing as an antitrust enforcer compared to being a state attorney general. Because I'm really close to the communities and the people I serve, and I could go to those communities and ask people, what do you think? And then go back to our team and say, here's what I'm hearing. And then we had a choice to make. And this is relevant to your question. I didn't just choose to oppose the merger. I chose to file our own case in Colorado because I believed we had a story to tell. And the facts about this merger in this county, I believed was relevant to stopping the merger. And we worked as a team with the Federal Trade Commission, who filed a case in Oregon, and actually Washington filed their own case in Washington. So there were 3 cases against this merger. I don't know if that's ever happened before, the merger. And I'm proud of the work our team did. I'm proud of the work we did with the feds and with Washington. And as you noted, we stopped the merger, and now they're fighting amongst themselves. And ironically, Albertsons is arguing with Kroger, saying to Kroger what we said, which is they had this divestiture plan that they said was going to be sufficient to observe competition. That's what they said during the trial. And now Albertsons is saying, actually, the plan they had wasn't good enough.
So, Logan, what did the grocery stores say in defense to all of this?
Well, first I just want to say thanks, Jan, for putting this panel together. Thank you to the Vail Symposium. I'm really glad that I get to be part of this tonight. But the defense really doesn't start at the granular level that Phil was just discussing. It starts at a much higher level of abstraction. The companies in the merger look at their landscape and they say, we're not big enough to compete with Walmart. We can't get the discounts that Walmart gets, and we can't compete with them on price. We're in a world now where people order stuff on Amazon, and particularly after the pandemic, when a lot of us did a lot of that and didn't actually go to stores in person anymore, the way people buy their products, including groceries, really changed. And the competitive dynamic therefore changed. And they found themselves on the outside saying, we don't think we can compete effectively unless we get more scale so that we can have the ability to drive some of the discounts that Walmart gets and have customers get the same prices in our stores that they do in a Walmart store. At a high level, that's what they were thinking. There are, I think, 2,300 some stores that were being acquired as part of the deal. And the merging parties recognized that the issue Phil identified was real and was a problem in a number of those stores. So they went back and forth. Now, I didn't work on this deal, but in deals that I've been a part of where we've done this kind of exercise, you try to figure out where the antitrust risk is, because in a deal where you're buying thousands of stores, there may be a whole lot of stores where there's no antitrust problem, where the parties don't compete at all. But there may be some places where they do. And we should maybe take a step back and talk about what an antitrust market is, because that's really relevant to this conversation. The law prohibits mergers or acquisitions that may tend to substantially lessen competition or create a monopoly in an antitrust market. And an antitrust market is defined in 2 different ways, 2 parts to the story. One is called the product market, and that is the set of reasonably interchangeable substitutes for the merging parties' products. So if you're doing a merger of Coke and Pepsi, the merging parties might argue that, well, if we merge and we raise our prices, people will start just drinking more coffee and tea. So that's got to be in the market. And if people would do that instead of paying more for Coke and Pepsi, then the market would be broader. But if people would pay more for their Coke or Pepsi, then instead of switching to coffee or tea, and that was a profitable price increase, then the product market would be limited to soft drinks like Coke and Pepsi. That's product market. Then there's also a geographic market component to the story. And in grocery store deals, that's really important, because the geographic market is the distance that a customer is going to be willing to go to get that product. So for some things, it could be global. But for something like, gasoline or grocery store products or a haircut, it's going to be really local. You're not going to fly to California to get a haircut. You're also not going to fly to California to get your groceries. So the geographic market in a case like this one is actually pretty narrow. So the merging parties, I think, put their heads together to try to figure out in which geographic markets there could be an antitrust problem because of this 3-2 or 2-1 issue that Phil identified. And then they agreed that they would fix that problem by selling one of the two stores that were close to each other to some neutral third party who would continue to operate it as a competitor. So you wouldn't lose competition in those towns or in those geographic markets. That was their fix to the antitrust problem they identified. So they came to the court saying, we need to do this deal to survive and to be an effective competitor, and we've got a fix to the antitrust problem that seems to exist in some of these geographic markets. That was their story.
And why didn't that work?
Well, it didn't work because of several reasons. First, the judge did not really buy, in either the Washington State case or the federal case in Oregon that the Federal Trade Commission brought, the judges didn't really buy the parties' argument about the product market. They said, look, grocery stores are a market, and Amazon doesn't really compete, Costco doesn't really compete. Other ways people can get the same sort of stuff that exists in a grocery store are not viable substitutes for a traditional grocery store. That was point number one that they lost on. Point number two they lost on was the judges looked at the fix that the parties had come up with, the divestiture of a bunch of stores, and the judges said, that's a terrible divestiture. It's not good enough. And therefore, that divestiture will not retain the competitive significance that currently exists in the merging parties today. And therefore, the deal was illegal.
Go ahead, Phil.
It's important to know a little bit of the history because there was a prior merger, some of you may remember, between Safeway and Albertsons. I wasn't involved at all in that merger. I wasn't paying attention, even though I had a local Albertsons that became a Safeway, and I knew some stores in my neighborhood closed because of it. But then this case came along, I learned that history. After that merger, they spun off stores, just like they were proposing here, the divestitures, to this company, and it was a not that well-capitalized company, and you've probably heard about these private equity deals, it was called Hagen's. They, I think, had all the land that they then sold, that they had owned, and then leased the land for the stores. And the private equity firm who got the stores were neutral pretty much just with that alone. So they all of a sudden were like, whether or not these stores make it is gravy for us. And the stores didn't make it. They went bankrupt. So they either disappeared, which wasn't competition, or they got sold back to the merged firm, which wasn't competition. So this prior Safeway Albertsons divestiture fix is what I refer to in these town halls as fool me once, shame on you, fool me twice, shame on me. So we approached this whole divestiture plan with a lot of skepticism and kicked the tires, and there was a great work that our team did. It turned out there were other plans too, not ones that affected Colorado, of these divestitures for grocery mergers, and basically none of them worked. They all failed, including ones involving CNS, the company that was going to acquire the stores from Safeway and Kroger. And so we were like, no, this isn't going to work.
Yeah, and one thing that I think hurt the merging parties was they went into negotiations over the scope of this divestiture, how many stores they would sell, and kind of lowballed. They came in with 413 or something stores, and then when they realized that wasn't going to cut it, they tried to up it to 579, I think it was, stores, which also the judges found to be inadequate. But the fact that they approached it that way and then had to suddenly defend CNS as the buyer of a much bigger set of stores that maybe CNS wasn't as well equipped to effectively manage and maintain the competitive significance of, really put them on their back feet and hurt them in the litigation.
This is an important point Logan's making, and the truth is the judges, because there are three judges, they actually gave the parties a lot of grace. If I were a judge in this, I would have been tempted to say to the merging parties, you don't get to renegotiate the fix in real time as the case is going on. Because what Logan mentioned about these changing facts, they didn't happen before the merger was filed. So they didn't file a merger plan that included the fix. They filed the merger plan with no fix, but over the time, including while the litigation was pending, they kept changing the terms of their proposed fix. And for us, that was obviously frustrating because it felt like we were up against a moving target. And I could have imagined a judge saying, excuse me, you got to submit your fix by a certain date. We're going to have discovery on your final fix, and that's it. And these parties got some grace. They got away with continuing to change. But I wonder if, even though the judge allowed it, the judges viewed it as, let's just say, dubious.
So competition continues to exist in the Vail Valley and throughout the country as a result, and the merging parties are suing one another for hundreds of millions of dollars for the failed merger.
Right, with the target saying that the buyer should have gone in with that bigger divestiture package and a better divestiture buyer
And a better
earlier.
buyer from the very
And then
beginning.
the deal might have gone through and they would have made billions of dollars. That's their
Exactly.
claim. Yeah.
So let's turn then to the Google case. Phil, talk about why you chose to bring the Google case and what the effect on consumers is.
I've been Attorney General now for a little over 6 years, and as I was moving into this job, I remember thinking and talking to people about what role antitrust would be in the portfolio of work I did as Colorado's Attorney General. And I said to some of my team members, just because I'm an expert in antitrust law, I'd worked at the Federal Department of Justice as a deputy in the antitrust division, I had written a casebook on it, had been involved. That didn't mean I needed to focus on this as Colorado's Attorney General. Literally days after I was elected, I got a call from the Nebraska Attorney General. Doug Peterson's become a friend. And he said, a number of AGs are really concerned about big tech and the power they have in the marketplace. We're looking at this. We could use your help. So I tell my chief deputy, I got this call, and I worry that me getting brought into this Google case, this is another lawyerly phrase, would be like an attractive nuisance, which the story you hear is like the people who have the pool in the neighborhood and they don't put any fence around it, so like kids go there and then maybe it's not safe for them. I'm like, I could get sucked into this, but we won't let that happen because we have a lot of other work to do. Well, long story short, I ended up co-leading the case with Doug. And the reason that I ended up getting sucked in is because as I looked at this case, I was really concerned about the market position Google has. And Jan did a great job introducing antitrust law. You can think about antitrust law as three buckets. Parties who have contracts with one another that might divide up markets, collusion. Mergers, like the Kroger-Albertsons one. And third, monopolization. A company who gets into a dominant position and can maintain that monopoly through what are called predatory tactics, which means you're doing things that isn't about competing on the merits, it's about how do you exclude rivals from having a chance to compete. Google got its monopoly in search, and then another monopoly in search advertising in the 2000s, you might call it, by competing on the merits. They built a better mousetrap. Google faced a huge threat around 2010. The world was moving to smartphones from the desktop, and Google faced a big challenge. Would they have their monopoly displaced as the world changed? And the Federal Trade Commission investigated Google and ultimately didn't bring any case. But I'll say with the benefit of hindsight, Google was able to lock up the smartphone marketplace in a way that rivals were not able to compete. What do I mean by that? They developed and pushed out the Android system, which was set up in a way that it made it overwhelmingly likely you end up with Google as your search. And then they bought, if you will, market share on the Apple iOS system by an exclusive agreement with Apple. And what we were looking at, now this is 2019, into 2020, we thought there were some new opportunities that would enable rivalry in search. We weren't sure what it would be. Could be what you hear called Internet of Things, or like your Alexa. Could be your car, could be AI. So we thought, we want Google to have to compete. We don't want them to be able to lock up control in the next generation of technology using the same sort of tactics they had used that had kept their monopoly, which is 90% market shares. And we then worked on a case, and this is a state coalition of 38 states, a whole bunch of other states, I'm not sure if it was like the rest, but maybe like 11, filed a case with the Department of Justice, and then we filed our own case. And the essential point was that Google was using techniques that was not about competing on the merits, but they were, in effect, like I said, buying market share, excluding rivals. And these rivals are pretty marginalized now. So Microsoft, Bing, or DuckDuckGo, they've got trouble getting to the marketplace because all the key ways people are going to get access to search, the default is always Google. And one of the key things we had to prove in the trial was that default choices really matter and that people often use the default. And Google was paying billions and billions of dollars for the placement so they could control, if you will, the user experience. This case bears a lot of resemblance to another case I was involved in during my time at the Department of Justice when I first met Jan. That was the Microsoft case. That was about a different market. It was about Microsoft maintaining its monopoly on the operating system by preventing rivalry from a browser. This is about making sure that Google could keep its monopoly in search and search advertising. And the reason it was important is consumers weren't getting choice. They couldn't get products that might have more privacy, for example. And other would-be upstarts were going to have a very hard time getting into the market because Google had created this chokehold position.
You want to describe the kind of arrangements they had, for example, with Apple?
I'm going to get the number wrong, but directionally $10 billion a year.
Starts with a 2.
What's $20 billion a year?
20 and
$20 billion a year, basically a transfer payment. And the net effect of that payment is Apple doesn't enter into the market to compete, which it might well have done so. Apple just cashes the checks from Google, and Apple doesn't give anyone else access to their platform. So you get an Apple phone, you go and you search, it's Google. Google's argument, I know, John, we'll get to this, is competition is one click away, but the reality is people don't change their search usage. They use the one that's set up for them, and that's Google, and they were paying $20 billion to get that position, and it was a lucrative arrangement for Apple, and it was a beneficial arrangement for Google because they maintained a chokehold in the marketplace. And then with Android, which is a Google product, they were able to also create structures that if you were a customer of Android, say you're Samsung, you're getting Android, you then get your Google Play Store, and it's also baked into that mix. You've got to use Google as your default. So think about those structures. Google essentially is able to dominate 90% of the market or 95% of the smartphone market for search because of how they have set up the marketplace and are buying this market share through these exclusive deals.
Okay, John, so how did Google defend this?
So first I have to say it's a total honor to be here at the Vail Symposium and on the same stage with Phil and Janet and Logan, and thank you for this privilege. And I also want to make a disclaimer. I've got some clients that are adverse to Google in these very cases, and so I'm actually on the other side, but I'll pretend I'm Google for a second. So most of what Phil said is true and hurts his case. Google got to a dominant position in search by being better. They came up with an algorithm that looked at, so how often in the then sort of Wild West of looking for stuff, did people link to something useful? They said, oh, the number of links to something useful, that's a signal that must be a reliable place to find the information. We'll rank that higher. And so as the plaintiffs, Colorado, with one group of states, and the Department of Justice, which brought the other big case, and they were tried together in front of the same judge in D.C. Everybody admits Google got its monopoly the old-fashioned way by being better.
Just for the audience, we've got similar age. Remember Alta Vista, for example? Like there were other search engines out there, and they disappeared.
Now, I want to ask them about who here uses Microsoft Bing on a regular basis? One, Norton. Two, yep, that's about right. In a room this size, about 2 out of 120-ish. That's the number. How many people use DuckDuckGo on a regular basis? More. Good. That's good. A little higher. But most people use Google, and Google's a verb, because it generally produces better results, or at least it did till very, very recently. Can I tell you the rest of the story though about Android? Because this is so cool, and I was there. I worked for Bill Barr, who had been the Attorney General of the United States, and he went to be General Counsel of Verizon. I worked for him for 10 years. And we had this problem that at Verizon, we competed with AT&T for cell phone service. This is an iPhone with my very sticky youngest grandchild. The iPhone was exclusive to AT&T. Verizon didn't have a cool smartphone to sell. Bill Barr and the head of the Verizon wireless business and I went to Mountain View to meet with Google because they had this product they wanted to tell us about. It was called Android. And I was in a room with Eric Schmidt, and this nerdy young guy called Andy Rubin comes in the room. And he's got this phone on a wire. He's plugging it in because the battery didn't work at all. So he had to plug it in. But it had a screen just like the iPhone, the early iPhone. It was an Android-based piece of software on what was a prototype of a Google Pixel phone, and it had the local, it had a map on it. And I remember being the snarky young guy in the room and asking Andy Rubin, well, can you show me where the traffic is? And he hit a button and boom, you could see where the traffic was. You could see the green was good and red was bad. But it was a competitor, this Android, to Apple. And so Verizon, the reaction in the room was, we have to have this thing. That was our chance to get a competing smartphone platform to Apple. Otherwise, Apple would be the only thing you have. DOJ has sued Apple too for being monopolist. But Android was a great innovation too. And of course it was logical for Google to put its own search engine on the Android platform. Now you can get DuckDuck, if anybody here has a Samsung phone, you can get DuckDuckGo or Bing on it. If you have any other Android-based phone, you can get the rivals. But it comes preloaded with Google's own products, which Google knows are good. So point number one in Google's defense, and I think it's mostly admitted, Google got there, at least for starters, the old-fashioned way by producing better products. In fact, really important competing products so that you have a choice of phones. You weren't stuck with Apple. You could also get an Android phone. And that also broke the lock between AT&T and Apple's exclusivity. So now, if you want good Verizon service, you can get an Apple phone. So that's the first point. Second thing is, when you get a monopoly, and I worked for a monopoly for a long time, for an alleged monopoly, what are you going to do? You're going to stop competing? You want monopolies to compete on price, right? Because more people benefit. If monopoly gives you a price cut, that's good. There's less competitive discipline. So, if monopoly offers you a price cut, take it. If monopoly offers you a better kind of service, you want them to keep innovating. You want them to keep investing in their products. And in this case, you want them to keep promoting their products. So the contracts that Colorado and the Department of Justice complained about were promotional contracts. I think I've got this approximately correct. Google makes $1 billion every day. I think its revenues are now up to something in the 300 billion-ish range per year. Paying $20 billion-ish to Apple as a premier place to promote its product. Why can't monopolies promote themselves? Monopolies supposed to go quiet and hide their light under a bushel. You have to go, find them. No, they promote themselves. So they paid Apple, and Apple was happy to take the deal because Apple wanted the best search on its product. Now, you can get DuckDuckGo on Apple. You can get Bing on Apple. You can get anybody else's thing on Apple. But why not get the best thing right on that first screen? Along with, by the way, Apple's own apps. So if you like Safari or Apple's other apps, you see those right on the Apple Music. But Apple wanted the best search. Google wanted to promote itself. That should be a legal contract. Third point is everything is changing. So the innovation that worked for Google and worked for Apple for so many years, it's now under contention by artificial intelligence. The world is changing so fast. These really good generals are fighting the old war. They want to fight the Microsoft war. They want to fight the war that the FTC, the Federal Trade Commission, cleared this stuff in 2010. They want to refight those old wars. The world's changing. You aren't going to get information by typing in a search query and getting a ranked list of things that you click some of. You're going to get, you put slides up, good. You're going to get Gemini or OpenAI or ChatGPT or Grok 3 to give you answers. I'll stop there.
So why didn't that work?
Because the one thing that Phil said too softly and too quickly, there was a bad thing that Google did. They went beyond promoting their product. They didn't just say, here's money, can we please have premier placement? They're competing. Microsoft was also competing for premier placement.
Here, John, if
No,
you want to change it.
No, I'm not going to change it. They also paid so that Apple would not preload rivals. So they went beyond promoting their own thing. They paid money to interfere with the independent promotion of their rivals. It's that interference with rivals, I think, is what got them.
Let me pick up something John said and pull that thread through. John said, if you're a monopolist, why can't you enter into contracts, and I'll say the word, that are exclusive, that gives your product the control? And the answer is, Justice Scalia said this dissenting in a case that I believe involved Kodak, where he said, things you can do when you're an upstart aren't necessarily things you can do when you are the dominant firm. If you're like an upstart with limited market share and you get an exclusive placement, that's not the same concern as when you are the dominant firm and you get an exclusive placement that precludes rivals. And they tried to say, well, anyone could do anything they want because it's just a click away. But the problem with that argument was, wait a minute, if it wasn't so valuable, why were you paying $20 billion for it? And the second problem was, and this was interesting that the trial focused on this, from a behavioral economic standpoint, which is the study of how people actually behave, the default really does matter in terms of how people behaved. And the judge didn't buy the argument that competition was one click away. And then finally, to John's point about fighting the last war, I would put it differently. I tried to say it earlier, which is, we want to make sure that for the next war, the AI war, if you will, Google has to compete on the merits and can't use this unfair, exclusionary tactic so that rivals can't get a foothold in the marketplace.
Can I say one more word? And this is a suggestion for your reading list. I was so impressed that for this talk, you were recommended Amy Klobuchar's book on antitrust, which is really good. It's funny. It's got cartoons. The footnotes were written by her husband. But I would suggest another book for you for the Vail Symposium, Why Nations Fail, written by Darren Acemoglu and James Robinson, two of the three winners of the Nobel Prize in Economics this past, was it October, just a few months ago. They answer questions about why different parts of the world succeeded and others failed or stagnated. Why did the Industrial Revolution happen in the United Kingdom is one of the questions. And the answer is because, not Germany, not France, not Brazil, not lots of other people that were the Asian or Middle Eastern countries that were also serving contention around the time of the Industrial Organization. The answer was England passed the Statute of Monopolies in 1623. And it sort of cleared the, what had been, it's just an amazing story of monopoly after monopoly. So this is from pages 187, 188 of this book I'm recommending. Extractive institutions manifested themselves in the form of monopolies, and more monopolies. A man lived in a house built with monopoly bricks, with windows of monopoly glass, heated by monopoly coal. In Ireland, it was monopoly timber. Burning in a grate made of monopoly iron, he washed himself in monopoly soap, his clothes in monopoly starch. He dressed in monopoly lace, monopoly linen, monopoly leather, monopoly gold thread. His clothes were held up by monopoly belts, monopoly buttons. I could go on, but it was like guilds. Everybody had to, you would win one piece of business and you were the monopoly and nobody else could compete. In America, we don't condemn monopolies if you get them through hard work and innovation. We do condemn interference with rivals trying to do the same thing.
Let me add one more point. Another famous economist, Joseph Schumpeter, talks about how you get innovation, and he uses a phrase, creative destruction, where you're not competing within a market, you're competing for a new market. And one of the questions that Schumpeter doesn't fully develop is, when you get those breakthrough innovations, are they more likely to happen under conditions of a monopoly or conditions of competition? And let me give you a case study for why, to double down on John's point, I believe in competition. The AT&T Bell system was a monopoly. It had every part of the phone system locked up, local, long-distance equipment manufacturing. Someone had a great idea that would have revolutionized the market for communications, fiber optic cable, Dow Corning. They came to AT&T, said, we've got this great new technology for telecommunications. AT&T said, we have our long-haul network. At that point, was it copper still or microwave, whatever?
Coaxial cable.
Coaxial cable. And they said, we're still depreciating it. And we will be for the next decade or more. And by the time we're ready to put in something else, well, we're not going to buy it from you, we'll make it ourselves. That is antithetical to entrepreneurship and innovation. After AT&T was broken up and there was a commitment to competition in long distance, Dow Corning sold its product to Sprint and MCI. Sprint did a commercial that was, you may remember it, I love talking to people my age, pin drop commercial. You can hear a pin drop. That was a way to make a statement about the quality of Sprint's network as opposed to the AT&T network. After that commercial, AT&T, they forgot about depreciating their network. They wrote it all off. That's what happens in competitive markets. And they moved to get a fiber optic network.
And so did Verizon. I have it at my home in Bethesda. So the audience has never, most of them, I have not been involved in these cases. Talk about the process. Logan, you do this on a day-to-day basis. What's the process, for example, of a merger? And Phil referred to economists. Talk about the role that economists also play in all of this.
Sure. The part that antitrust plays in a merger actually starts before the parties even sign the deal. That should, at least. On a deal like Kroger-Albertsons, where you know there are going to be these geographic markets where someone like Phil is going to say there's an antitrust problem, both parties are going to have their own antitrust lawyers trying to figure out where the landmines are and what we're going to need to do to fix those landmines so that we can get our deal to close through the merger review process. So you start at the outset, and sometimes even hire economists then to figure out, particularly on a deal where you've got thousands of stores like Kroger-Albertsons, and you're looking at 2,300 geographic markets to figure out who the other competitors are in each of those markets and how vibrant competition is. Phil mentioned the price differences that exist between markets where competitor X exists and where they don't. All that kind of analysis you could do even in the front end before you sign your deal, so you can agree in the merger agreement what you would have to do to fix the antitrust problem. And in fact, in Kroger-Albertsons, they did agree to a divestiture cap of, I think it was 690 stores, a number higher than the number they actually divested, which is one of the reasons that there's litigation now over whether the buyer did enough to get the deal cleared.
Can I say a word about process?
Yeah.
From the point of view of a plaintiff or a governmental enforcer, this is the sport of kings. So we're in the right place to talk about it. You can't bring an antitrust case for less than $50 million. You will spend half of that on the famous economists, the volume of documents, the number of issues that have to be decided. Antitrust cases take so long and they are so ridiculously expensive. We have two federal agencies, the Federal Trade Commission and the Department of Justice. Fortunately, we have states. We have 50 states and the District of Columbia actively enforcing, and those additional resources are also taxed trying to enforce the antitrust laws. But it's unbelievably expensive. At the end of 2022, I proposed a change in the law to benefit state attorneys general so that they could move their cases faster. And that was one of the few things that passed at the end of that Congress. But anyway, the state AGs have done just terrific work here in addition to what the federal enforcers have done.
So, you're absolutely right that antitrust case like these Google cases will take years and years. It'll get appealed all the way up to the Supreme Court, possibly. The Kroger-Albertsons style case, a merger case, is actually very different because it has to happen in a pretty narrow window of time where the deal falls apart, and the judge knows that. So the government typically doesn't go through its entire process. In the Federal Trade Commission, they have this administrative law judge process. Nobody ever does that. That never actually happens because you have to go to a federal judge to get a preliminary injunction to stop the parties from merging while you do this other administrative process. And everybody in the courtroom, the judge and the government and the merging parties, everybody knows that the judge's decision on this preliminary injunction, while it's just preliminary, is actually the whole ballgame. Because if the government wins and the parties have to sit through a 2-year administrative process at the Federal Trade Commission, their deal's falling apart. The financing won't last that long. Employees are going to start to leave the target company because they don't know if they're going to still have a job at the end of this. And the whole value structure of the deal can fall apart. And if the merging parties win and they get to close their deal because there's no injunction, then the government is all of a sudden trying to undo a deal that's already been done, and the merging parties have scrambled the eggs, and they usually just go away and go on, put their resources towards another deal. So that preliminary injunction proceeding, which happens usually over a span of 9 to maybe 12 months at the outside, is the entire ballgame. And parties do spend millions of dollars in that process, but it's much, much, much more contained than a sprawling antitrust conduct case like the Google cases.
Well, and going back to the analysis that Logan talked about the parties hired lawyers to do before they ever signed the deal, sometimes we tell them they can't do the deal. Sometimes we tell them there is not a prayer this deal will get cleared. You should walk away. And especially if we're representing the seller, we say, you're going to lose your business during the 12 to 15 months that this is going to be pending. Your employees are going to leave. Your customers are going to leave. And the potential buyer actually says, okay, I win this in 2 ways. I get the merger done, or I destroy my rival through the process.
They'd wither on the vine while they're hanging out to dry for a year.
Exactly.
Yeah. And I like to tell my friends at the government that I'm their first line of defense, because I'm talking to the CEO or the general counsel of a company about a potential deal well before it's ever something that gets filed with the government. And I can be the person to say, guys, we can't do this. This is going to be a waste of your time and money. Let's try something else.
Well, I want to give everyone here a reality check. You're hearing from what I would call lawyers' lawyers. There's lots of definitions in that term, but here's one. A lawyer who another lawyer would want to hire. And a lawyer's lawyer thinks about one's reputation over the long term. There are a lot of lawyers who are short-term oriented, which means when that company says, can we do this deal? Can you get this through? Instead of saying what Jan said, or what Logan said, which is being intellectually rigorous, honest, and acting with integrity, a lot of lawyers who want the business will say, sure, I can get it through. And then later, when it doesn't happen, they'll find some way to try to excuse what happened or blame somebody. And it's a short-term game, because I think the longer-term game is to build a reputation that people can trust what you're saying. But for lawyers looking for a short-term opportunity, I'm not sure they're always going to follow the lead that you guys just outlined.
No comment.
I actually told a client once that the deal was so bad that the only people it would be good for was my law firm and the economists we would hire. So we've got these big tech cases. In addition to the Google case, we've got cases against Meta, we've got cases against Amazon. What's going to happen to these cases with the new administration? Phil, have you had discussions with your counterparts in the federal government?
I have, and I've had discussions with my counterparts in the state AG community. And for a lot of people who are somewhat concerned about the state of our politics, the concerned about the level of polarization, antitrust is a relative bright spot. And I want to acknowledge, I mentioned before, Doug Peterson, a Republican from Nebraska, Jonathan Skrmetti, a Republican from Tennessee, who have been my counterparts on antitrust cases that include not just the Google case, but a case against Ticketmaster Live Nation, another case against RealPage, which is a software program to enable collusion between corporate landlords. And this reality that I know for some sounds too good to be true, that antitrust is a bipartisan enterprise, it's true. When we brought this Google case, it was the original Trump administration bringing it alongside the states.
Bill Barr brought that case.
Bill Barr. And then it got litigated by the Biden administration, and the remedy process will be under the second Trump administration. So I am, relatively optimistic, at least when it comes to antitrust, that we can have a continued bipartisan commitment to effective antitrust enforcement. And there's some very powerful reasons. I love John's point about this idea of competition is an American idea. It is not a partisan idea. And what you have seen, which I think is really important, is a number of state AGs all across the spectrum are looking at the sorts of cases we're talking about, and they're saying consumers are getting the short end of the stick when markets are monopolized or when mergers like this Kroger-Albertsons one are being pushed. And my friend, the Wyoming AG, a Republican, opposed that case just like I did. So I am optimistic on this point. Obviously, the proof will be in the pudding, and I'll make sure that I continue to do all I can to keep antitrust as a bipartisan enterprise.
So Gail Slater is a friend of mine, and she had her confirmation hearing last week, and she hasn't had her Senate vote yet, so I'm not going to say anything to jinx that, I hope. But she's very, very solid. She worked in the first Trump administration. She would have been a deputy if President Trump had been elected instead of Biden. She would have been a deputy in the antitrust division then. I think she'll be a very effective enforcer. Roger Alford, this may not have been announced yet, will be the principal deputy to Gail. He's right now a Notre Dame law professor, but he was a deputy in the antitrust division under Macon-Del Rahim. That would have been Trump 1. He's well known to Phil because he's been helping the Texas Attorney General in a significant Google case. He's a very effective lawyer. And the guy you don't know on the right, Omid Asefi, I introduced him to Gail Slater. He is an unbelievably aggressive young man with good judgment and wonderful charm, and you'd be delighted to be in his presence. He's running the place on an acting basis until the Senate confirms Gail Slater. But his portfolio is criminal enforcement. And so, as an example, over the last 5 years, the amount of criminal fines and restitution for antitrust violations, $65 million over 5 years. That's $11 million a year. I think Omid's going to get $1 billion a year.
We should explain this point because we didn't touch on it. In that category, collusion, when Jan said, you take Colorado, I'll take Nebraska, that's not just illegal. It's what antitrust law calls per se illegal and criminal. And you can go to jail for it, and you can have these criminal fines. And for those of you who want a little bit of background, the movie you need to see is called...
The Price?
I've seen the movie.
The one about...
It's about Archer Daniels Midland.
Yeah.
I'm thinking The Insider.
The Informant.
The Informant.
Yeah. Yes.
Matt Damon is the star. He gained a lot of weight for the role, so you might not recognize him right away, but yeah.
And Kurt, who's the Wall Street Journal reporter?
Oh, yeah.
Who wrote the book called The Informant. So if you like to read the books, read The Informant, but the movie is very watchable, and it captures the making of one of these criminal antitrust cases for price fixing. And Archer's Daniels Midland was one of the most powerful companies in America, and people went to jail and they paid a huge fine, and that was 30 years ago, and I think that's when this started really driving higher and higher.
Well, there's a great inside story about that case because the Justice Department had this informant, and they actually placed a camera in hotel conference rooms where the companies were getting together to fix prices. And it was in a lamp. And this lamp gets moved from Hawaii to California to New Orleans to Florida. And somebody I knew who was in the antitrust division at the time said, There were no women involved in this, because if women had been involved, they would have said, why is this in every single conference room in which we're meeting? And they actually had videotape of these companies sitting up and drawing on a whiteboard who was going to get the next contract.
Which really highlights the importance of diversity in the boardrooms of companies in America.
Exactly. But the videotapes were made available by the Justice Department to companies to use in their antitrust compliance program. They didn't just use them at the trial. They made them available to law firms and companies.
Well, that's actually a point, getting back to what Jan and Logan were saying. At its best, antitrust is this self-enforcing framework where private counsel know the rules. You don't collude and agree with your rivals on prices. I didn't mention this before, so it's a good segue. When we investigated this merger in Kroger and Albertsons, we found out that during a prior strike, when King Soopers was dealing with the strike, King Soopers and Kroger and Albertsons entered into not one, but two contracts that were collusion. First, they said, let's agree not to hire each other's workers when we're on strike, so we'll keep workers' wages lower. Second, they said, let's agree not to solicit our pharmacy customers because they're particularly valuable for these grocery stores. Those are two agreements that are illegal under state and federal antitrust law. And in our case, we not only sought to stop the merger, but to hold them accountable for those illegal agreements.
So cases like Google and the grocery store cases are tried to federal and state judges who might be hearing a contract dispute today and a tort case tomorrow, and then they get this huge antitrust case. How do they handle these cases, and are they sufficiently impartial in your experience?
I can go first if you want. That is a very tough question. So it is difficult to distill down a super complex antitrust case that involves very high-level complex economic analysis and sometimes very complex legal theories into a digestible story, right? I mean, the human brain responds to stories. And usually, whichever side can tell the better, more compelling story in any case will win, is much more likely to win. And so in an antitrust trial, particularly a merger trial, which again is happening really fast, and you don't have years to build the discovery record, you have to figure out what that compelling story is. Is the compelling story that these two grocery stores need to merge because the world has changed and Walmart is the dominant force and no one can offer the low prices Walmart does because no one has their scale, and grocery margins are really, really low to begin with. So the only way for us to compete effectively is to get that same scale so that we can play the same game. That's a meta narrative. That's a story that might resonate with a judge, and the lawyers will typically try to hit that framework of a story or a narrative that will resonate with a generalist judge who might not really understand some of the econometric analysis that's going on, but will understand what happened in the pandemic and how everyone changed the way they bought groceries.
But then the enforcers present documents like the document that showed that prices were higher in Eagle than they were in Vail.
I said this before. This county's experience, as revealed by the party's own documents, put them in a very deep hole. Their whole point about Amazon or Costco was somewhat undermined when you could look at what happened in Eagle. And they didn't have much of an answer to that. And I would just say Judge Luxon was a very observant judge who was interested, took that in, and our experience, he's not yet ruled, so I'm giving you my take, is it wasn't hard for him to get a good sense of it. Judge Mehta in the Google case, also a very careful judge. And I actually think it's a strength that antitrust law has to be tried to generalist judges, because you have to be able to articulate your theory of the case, another way to say what Logan was saying, in an understandable way. You have to be able to present information in an understandable way. And I don't want antitrust law to be determined by who can do the most teched up econometric analysis that gets more and more complicated so almost no one else understands it other than experts. I think there's a discipline and a value for the case to be understandable and have to be presented for a generalist judge. And in both the Google case and in the Kroger-Albertsons case, we were able to do that. And I believe that judges stayed on top of it. There are obvious times when someone might look at how a judge decided a case and shake their head. And that can happen in any area of the law. But on the whole, I will tell you, I am proud of the American judicial system and legal system. And when you look at how we've managed antitrust law, I would say it's part of that strength.
Yeah, just to underscore that, in the Kroger-Albertsons case, the merging parties did present some crazy econometric analysis that had never really been done before, and obviously it didn't work very well. And one reason for that was the judge looked at the documents and the statements of the parties and put a lot more weight on those than some crazy theory that a nerdy economist from an ivory tower was able to put together. And I think that's really important because in most cases that judges are hearing, they're trying to figure out what happened. Did the defendant murder that person? Right? Did the defendant run the stoplight? In a merger case, the judge is trying to figure out what's going to happen in the future. If the merger happens, will prices go up or will prices go down? Will these two stores merging make them a better competitor to Walmart and we all pay less for our eggs? Or is it going to make them a monopolist in certain towns where people are going to pay double for their eggs? Which is going to happen in the future? And when you're trying to figure out what's going to happen in the future, that's really tough.
So if you're doing something wrong, your people are going to write it down. Any organization of any size is, they're writing truthful notes to one another. In the case that Phil and the Department of Justice won against Google Search this last year, a thing the judge didn't need to get to was a program set up by the General Counsel of Google where everything sensitive, everything related to the topics that were going to be in this antitrust case were to be communicated through a version of chat inside of Google. They had a special chat network for communicating with one another, and the chats were to be deleted after 24 hours on a systematic basis. And if you had something that was going to survive more than the length of these disappearing chats, you were to add a lawyer to the Ray line. So this is to Fred and Sally, but I'm going to add Joe, the lawyer, and then the instruction was, and ask the lawyer a question. And the interesting thing was there are these huge numbers of documents that were withheld as privileged because there was a lawyer on the document and somebody asked a question, but the lawyers never answered the question. And there was a trial in California, and the judge asked one of the Google in-house lawyers, so why didn't the lawyers answer these questions? And she said, well, these were fake privilege. They weren't real. But if you know you're doing something wrong and you destroy the evidence, it's a signal to the judge or the jury that there was something to hide.
Yeah, that's a bad answer for the defendant.
This is where just giving you this awareness. The search case we've been talking about is actually one of 3 cases that I filed against Google. The other one, that the case John referred to, involved Google's approach on what's called in-app purchases, and that's the one where the finding
the App Store.
The App Store. Spoliation is often when you fail to preserve evidence or withhold evidence.
Destroyed on purpose.
Yeah, and so we got that finding in that case, then settled. The third one, we're still waiting for a determination. It's on ad tech, the technologies on how advertising is sold.
Death of newspapers.
And, I like our chances in that case too. The important point, though, that John's making is if you are withholding evidence and you can get a judge to take a close look at it and you get one of those instructions, it's a very powerful tool.
Well, let's open this up now to the audience because you've now had a crash course in antitrust, and maybe it's prompted some questions.
So in the supermarket case, you outlined the consumer injury potential, the Eagle price being higher. In the Archer Daniel Midland circumstance of price fixing, clearly there's a consumer injury the price is higher. What's the injury to the consumer in the Google case with search, and is that a necessary condition to prevail in an antitrust claim?
It's a very important point, and it's worth noting Google was a unique factual situation because the product, search, didn't have a price associated.
It's free.
It's free. One could have argued, therefore, you can't bring an antitrust case, which would raise a question. If you had a merger of all the radio stations back when people listened to radio, because radio is free, are they all allowed to merge? What would the answer be? No. Why not? Because radio stations compete by having less advertising. Search engines do compete, they just don't compete along the terms of price. They might compete, for those who raise their hand for DuckDuckGo, by saying, we are going to respect your privacy more. Or they might compete by being more innovative and providing better results, like Google initially did against Alta Vista. So the fact that it's not price competition doesn't mean consumers aren't harmed by a lack of competition. And from the Microsoft case, there's a very important precedent, which is to show harm to the competitive process is enough. You don't have to prove that there would have been another competitor who would have necessarily been better. And obviously, if you had to ramp the burden up that high, it would be harder to win a case. Instead, antitrust law, as the Microsoft case outlines, has what I think is a pretty sensible presumption. Consumers will be better off when you have full and fair competition, and so allowing a dominant firm like Microsoft or Google to prevent rivalry is bad for consumers.
But there is a price. So, Google gives you search for free, and that takes your attention and your information, and then it sells that either to advertisers. So there's money coming from advertisers. Remember 800 telephone calls where you could make a call for free to somebody and order out of a paper catalog? But the catalog vendor is somebody's paying for that call. Just the other side, it's like reverse charges. So Google's making money with advertising. It's also making money when you click a link because it makes money on the linked page. So Google, can change the search ranking to what gives it more money on the linked pages. It can charge higher prices for advertising if DuckDuckGo and Bing are unable to monetize.
We antitrust nerds call those two-sided markets, where you've got sort of people on one side of the market who are getting a service, and people on the other side of the market might be paying into the platform that is connecting those two sides of the market. And so if you can show harm on one side of the market, it might not be that there is detectable harm on the other side, but there still could be an anti-competitive effect.
If search advertising is too expensive, everything you buy is going to be a little bit too expensive.
With respect to antitrust, does what happens in the EU have any impact on the United States and vice versa?
It's a great question.
Absolutely.
Sometimes the EU blocks mergers that the U.S. thinks are efficient. Honeywell and was it GE? It was a merger that was going to be more efficient, and the Europeans thought, well, our domestic industry won't be able to compete as well. The U.S. blessed it, and the Europeans blocked it. But in general, the Europeans and the Americans have been pretty much aligned.
They coordinate remarkably effectively. The European law is somewhat different, but the fundamental concepts are very similar. And the authorities communicate regularly so that they are coming out in the same way. And the parties need to be sure we're saying the same things to authorities all over the world, because they're all going to figure out if we tell one something different than the other. It's created a complicated process where we will have 30 or even 40 countries that we have to coordinate with.
You've all been very measured in your comments about antitrust law, which I appreciate as an audience. But you had on one of your slides a picture of Elizabeth Warren on a billboard saying, "Break up tech." taking things kind of up a level beyond the technicalities of antitrust, there are some things that require such large investments that only big companies can do it. You're always going to find bad documents or stupid things people say if you've got a big enough company. But the fact is, some investments, such as AI, can only be progressed by large companies. And summarizing antitrust as big as bad, which you haven't said, but certainly in the political realm, it has been said many, many times by both administrations, you get away from the technicalities and could crush innovation. Comments?
So the AT&T Bell system was a wonderful, wonderful thing. It invented transistors and lasers. It facilitated the early space launches. It did amazing, amazing things. I once took the deposition of a guy at AT&T who had discovered the cosmic background radiation that demonstrated the Big Bang of the universe. I asked him in his deposition, well, does this disprove the biblical story? And he said, no, that's what I teach in Sunday school. But it was a wonderful thing. But I think it's even more wonderful that we have several competing telephone companies now.
This is an important point that people say, will big companies create great innovations? And part of the problem, those big companies tend to lack the incentive and the drive to deploy those innovations and to be entrepreneurial. Xerox was a big company sitting on an incredibly valuable patent, and they created what was known as Xerox PARC. Xerox PARC invented some incredible breakthroughs, the graphical user interface. They didn't deploy any of them because the company was a fat and lazy monopolist. And the problem for companies who are content and lazy is they're not driven to compete in the marketplace. And if you see industries where you do have a dominant firm without the benefit of competition, you'll often see that firm will get, lazy. They'll sit on their laurels. And this is a challenge for our whole economy. How do we build a competitive economy where companies have to stay on their toes?
So the alternative to antitrust enforcement is regulation. And AT&T Bell system, and you could have a regulator of Google if you wanted to keep a single search monopoly in business.
Which Europe is doing, by the way, in reference to the previous question. They're trying to regulate big tech instead of breaking it up.
Regulators don't go away unless a Doge comes. Regulators are kind of forever things, and they get captured. They get captured. I've been there. I've done that. The regulators get captured, and it's expensive. The alternative to regulation is to try to be surgical. And antitrust is an alternative. Robert H. Jackson, when he was head of the antitrust division before he became AG and then on the Supreme Court, he persuaded his president, give me a chance, let me try antitrust first, and then do regulation second if I don't succeed.
I don't think anyone on this panel thinks that big is bad. We think big with abuse is bad. And yes, there are often bad documents, but there was a concept that was developed called the deranged middle manager defense. Which was basically, oh yeah, he wrote that we were colluding, but he really didn't know what he was talking about.
When Trump was first elected, financial stocks appreciated sharply, and they thought it was because there were going to be less antitrust, or he'd be more lenient when it comes to that. And now he came out and he said that he is not against mergers and acquisitions. He's not for them. He's going to let the market decide on their own. And that caused the financial stocks to go down. So what do you think going forward the administration is going to do? Or you mentioned Gail Slater. I didn't know about her. Do you think she's against mergers and acquisitions?
It's much more nuanced. Logan should speak to this, but the Federal Trade Commission is fully staffed. They're in operation today. They're blocking mergers that they determine, looking at all the facts, will be bad, like local groceries here. That's a bad merger, and they're letting other mergers go through where they think that it's going to be a positive or at least not bad.
So in the 1980s, when the Reagan administration was in charge, there was a marked decrease in antitrust enforcement. The Republican Party of that era didn't really believe in vigorous antitrust enforcement. I don't think that's true of the current version of the Republican Party that's ascendant now. And in fact, there's a nickname for some of these people. The head of the Federal Trade Commission, who was a Democrat appointed by Biden, was named Lena Khan. And she was very left of center on merger enforcement and some other things, and in her time as the head of the Federal Trade Commission. And there were a number of Republicans on Capitol Hill who really liked what she was doing. And the press dubbed these people conservatives. They're conservatives in pretty much every way, except they love what Lena Khan does. I think J.D. Vance said that the only person in the Biden administration who he thought did a good job was Lena Khan. So I think we will continue to see vigorous antitrust enforcement. It will look different. There will be different political priorities, I think, that are applied. But we're not going to go back to a 1980s era of more lax antitrust enforcement, I think. And even if the federal government were to try to do that, you got people like Phil Weiser who are going to step in at the state level and make sure that the deals that should be blocked are blocked.
Let me also offer one cautionary point consistent with acknowledging some of the unconventional characteristics of our president. We haven't seen since Richard Nixon anyone in the office of the president telling the antitrust agencies how to decide cases. And I agree with what John and Logan said. Philosophically speaking, there's a real opportunity to have a strong bipartisan antitrust consensus. What I very much hope doesn't happen is what happened under Richard Nixon, where he said, I like this company, ITT. They just gave us a good donation for the Republican National Convention. Give them a pass. Because of that conversation that was recorded with the Deputy Attorney General, we have something called the Tunney Act, which now says if there's a settlement in an antitrust case, you've got to show that the settlement's in the public interest, and there's opportunity for discovery to make sure there's no hanky-panky.
The one case where I think that President Trump may put his finger on the scale is the proposed merger of the PGA and Live Golf. which has been is being investigated at the Antitrust Division and by the European Commission. And the PGA, when they put out their announcement of their deal with Live Golf, said, we are going to eliminate the competition that has existed with Live Golf. They didn't invite their antitrust lawyers to review the press release in advance.
Put your forward-looking hats on, and with all your experience with telecom, Apple, Google, look forward at what's going on now with the advent of satellite communication to smartphones and restricted technology or hardware, where the hardware is proprietary to the satellite systems. What do you see as anti-competitive or monopolistic hurdles that would be facing that industry in the near future?
I don't know nearly enough about the tie between the equipment and the service. The hardest thing in the satellite business is getting the orbital rights, the right to use spectrum at different places around the Earth. It's just a huge entry barrier getting the rights to the satellites. But our head of DOGE has done a fantastic job of launching satellites and creating competition that wasn't there before. Many people tried that. There were Bill Gates and Craig McCaw had an idea called Teledesic. There were a bunch of earlier attempts. None of lots of buzzy bees around the globe providing communication, and Elon Musk has been the first to achieve that. That's an example of achieving a dominant position just by being better and faster and investing. With three
So basically three wireless providers and then one new entrance into there that's already tied in with T-Mobile, how do you look at that from an antitrust standpoint of saying, how does that not consolidate that industry into, less than, a stronger, more dominant player?
I'll talk about wireless. That was a merger between Sprint and T-Mobile that was challenged by a number of state attorneys general. We ultimately accepted in Colorado the remedy that they put in, and the judge in that case rejected the state AG challenge, and the one of the core premises the judge had was that Colorado's DISH network could build a fourth wireless alternative to the three. And there's been a lot of economics around how many players in a market do you need to keep a market more competitive and to prevent what economists call an oligopoly, which is obviously not the same thing as a monopoly, but it's the next worst thing. It's where you have, let's call it 2 or 3 players who are cozy with one another and don't bring the same level of competitive pressure. I share, I think, the concern you're noting that if we end up with only 3 players or only 2 players within wireless, such a crucial platform for our information age, we're going to be worse as a society. And so we'll see whether that judge's prediction that DISH Network's fourth rival wireless network can be a true alternative to the other 3. And as your question also adverts, some people might suggest satellite communications will become so significant they will be an alternative for both broadband and other forms of telecommunications. The big challenge with satellite is the delay going all the way to satellite and back. So we'll have to see on that too.
All right, over here.
Thanks so much for all of your comments today. They've really been interesting and erudite. I'm super interested in narrative, and I like how you've woven the idea of narrative into all 4 of you have woven the idea of narrative into your comments. Now, I'm thinking about the narrative of our justice system and all the great things, and I was really heartened to see the slide that you put up here. I'm wondering, though, going forward, and in the past, what are the teeth that the Justice Department or that the judges use to make sure that businesses follow through with these antitrust types of legislative decisions that are put into place? And going forward, will people have reason to ignore those, as I see many of the teeth that I would normally associate with consumer advocacy being rooted out of our system and people being fired and that kind of stuff?
It's super hard work. The work needed by enforcers is difficult. That the people that do these jobs don't get paid enough. You know, the Logan Breeds, the John Thornes of the world get paid like lawyers. But the people that take the public enforcement jobs are getting paid a lot less, and they're working really hard. And so that's a critical constraint on enforcement. But the penalties are big. A cool feature, in addition to jail time for hardcore price fixing, is there's something called the leniency program. If one of you were involved in price fixing or heard about price fixing and happened to mention it to an antitrust lawyer, they tell you, let's go disclose it. We go to the Justice Department and we will rat out all the other cartel members. The first one to do that avoids criminal penalties. And so there's an incentive. Any one of the cartel members talks to a lawyer and says, "Whoop!" You go to justice, and then you're wearing a wire, or you're putting something in the lamp that keeps moving. And
Well, and if you settle a case with the Justice Department or the Federal Trade Commission, say a merger case, they put in place a court order. There are enforcement mechanisms. You have to make reports to the agencies. Sometimes there will be an independent observer appointed to be sure everybody's complying. One of the cases Phil's got going right now is against Live Nation. They had a consent decree with the Justice Department, and they basically admitted they didn't live up to it, so the term of the consent decree got extended.
Your point's an important point. We could win the Google case. If we don't have effective remedies that are then enforced, we're not going to end up achieving the goals we had. And that's something we absolutely have to take seriously.
Omid Sefi, though, he's going to go from 11 million a year of fines to $1 billion a year.
I know that there are more questions out there, but we try really hard to stay on time. I think we could have gone on quite a lot longer. But I'm going to close us. Could we please give our panel a round of applause? Jan McDavid, Phil Weiser, John Thorne, Logan Breed.
Thank you.